Hey, good afternoon, everybody, and welcome to this lecture in the STL Public Lecture Series. I would like to welcome everybody here in person and also to those of you who are joining on Zoom. We're very honored today to have as our guest speaker, Professor Konrad Osajda, who serves as professor and chair of commercial and corporate law at the University of Warsaw, Faculty of Law in Poland. Professor Osajda's research interests are in company law, business law, and also contract law, and he writes from both European and comparative perspectives. He's also involved in practice as well, besides his academic work. He is a member of the Studies and Analysis Office of the Supreme Court of Poland. He is also a member of the Codification Law Commission in Poland. He's written numerous books and articles in his areas of expertise on company law and corporate law. I could also point out one project that Professor Osajda has been involved in. He serves as editor-in-chief of the great commentary to the Polish private civil law. So he's somebody who is, of course, doing scholarly work, but also very much involved in law making and legal reform in Poland and Europe more generally. And Professor Osajda today will speak to us on the topic of, as everyone can see from the slide, Laboratory for Company Law Innovation, the new Polish type of company, simple joint stock company. Is it a good answer to the needs of startups? Professor Osajda will speak for approximately 40 minutes, after which we will open the floor to questions. I would like to now give the floor to Professor Osajda.
Thank you. Thank you very much, Professor Hall. Thank you very much for inviting me to this excellent transnational law school that I love much because I think that 21st century is comparative for legal studies. It must be transnational. It is the only one correct approach. And I'm very honored to be here and to be able to deliver this presentation that will focus on kind of three research questions. Firstly, we will look briefly and we will discuss briefly how to change company law, how to amend company law, what is the best methodology, what are advantages and disadvantages of kind of two different approaches that I will talk about. Then we will look at some innovations in the field of company law through the lens of a new Polish type of company that was recently introduced into Polish law, simple joint stock company. And finally, to summarize, we will try to pose the question and try to look for answer to this question. Is it necessary to introduce any specific form, corporate form for startups? What startups want from company law? How company law could address the needs of startups? And it will be linked to this new Polish type of company that is designed for startups. Let's begin first from methodological dilemmas, amending versus introducing new company forms, then some key innovations in the field of company law on the example of Polish simple joint stock company, and finally about startups' needs from the perspective of corporate law. When we think of amending company law, we know that it's a constant process. We have to do it all the time. But then we have an important issue to address. How to do it? Should we just change the law on the existing companies, like limited liability companies or corporations? Or maybe we should think of creating a legal sandbox. So introducing a new type of company that could be a ground for introducing and testing innovations, and then to transplant them to the regulations of the existing legal corporate forms. So answer this question, let's first look on the consequences of the first approach. when we just want to change the rules on the existing types of companies. When we do so, these changes will apply directly and automatically to the existing company. It may have a lot of advantages because when we think of amendment, we hope that it's going to be better, that the new law is going to be better, is going to improve the legal regulation of the company. However, there are a lot of risks involved because we are operating on a living being, a company that is in business. So when we change the law, it may create chaos because, for example, it may require from the companies to amend their articles of associations, their charters. It may take time and it may result in some complex issues for the companies. It's even worse where the change, the amendment happens to be bad because it may result in irreversible damage to the existing company. Moreover, we may end up with companies that may be better or worse adapted to the new regulation. So it will take time to absorb the new law and to have kind of common standard for all companies. Moreover, it may result in costs because companies, for example, will have to hire lawyers. For us, as lawyers, it's not such a bad thing, but generally, they will have to hire a lawyer to ask them to help them to amend the articles of association and to be compliant with the new regulation. Finally, such a change is unavoidable. It will apply to all companies, regardless of the fact if they want it or not. So there are a lot of important risks. Maybe then it's a better idea to do it like they do in science and to create an artificial environment, a sandbox, in which we can test new company law innovations, and if they work, only then to adapt them, to transplant them to the existing company. In this case, the new rules would apply only to the newly incorporated company or the existing companies that decide to reincorporate. But this approach has its own risk. Firstly, the new corporate form will be totally unpredictable and totally new. We don't know how the new rules will be interpreted, will be applied. There will be no case law regarding the corporate form. And then, as a result, if we have contractual partners, they may not be adequately protected. Moreover, you can't imagine, you can't create completely new company. So this new form, for sure, will borrow some regulations from the existing rules. But then you have a question, how they should be interpreted in the new context, in the same way or in different way than they are interpreted in the old environment. Moreover, this new form in practice may be totally unpredictable because lawyers most likely would not recommend to their clients to set up this kind of new company as something unpredictable and unknown. It may also make the entire corporate law more complex because there may be too many different types of companies, of corporate forms. And finally, even if a solution is tested in such an environment, if it is transplanted to the already existing company, you never know if it will work. So we have risks in both cases. Then there is a question, how to change company via amendments or via creating a new corporation? The answer seems simple. In case of small changes, the amendments probably is the better way. But in case of innovations, radical change, it may be better to think of a new corporate form to introduce them there first. And then this solution was already tested in Poland. And we had this discussion, and the idea, the conclusion was that we introduced a new type of company, and we introduced a lot of legal company law innovations into the legal regime of this corporation. So you can learn from experience of others, not only from nothing. Now, let's look at these innovations and the new Polish simple joint stock company that may work and may be thought of as a kind of laboratory, legal laboratory for company law innovation. And first of all, we need to keep in mind that when you talk about innovation in the company law context, this is complicated because it strongly depends on a jurisdiction. Some jurisdictions are better developed than others. So if you are innovative in one jurisdiction, it may simply mean that you just borrow a solution that is already tested somewhere else. Then innovation is always very much connected with jurisdiction. But this is the same with law. We don't have Polish biology, German biology, American biology. We don't have French physics, Korean physics, or Chinese physics. But we do have Polish law, German law, and American law. So law is always connected with a certain given jurisdiction. To understand this new Polish law, you need to see a little bit of the context and a little bit of short history of Polish company law and current regulation. Poland regained independence in 1918. Before there was no Poland on map. It was conquered by neighboring countries, Germany, Austria, and Russia. The law, the commercial law, was unified in 1934, but the new law that we have in force now, the Commercial Companies Code, comes from 2001. And Polish law, Polish commercial corporate law, is based on the model of German law and inspired by German law. However, the newest amendments are independent, and this is the concept of the simple joint stock company that is in force since 2021, and something that I want to talk about today, the new Polish law on groups of companies introduced in 2022. Now, to see this new Polish company on the map of other Polish companies and partnerships, I will very briefly list the types of Polish partnerships and we have civil partnership regulated in the Code Civil, registered partnership, professional partnership, limited partnership, a limited joint stock partnership. So the catalog is kind of typical for civil law jurisdiction. And in terms of companies, we have a limited liability company, LTD, the new one, simple joint stock company, and typical joint stock company. When there was a lot of discussion about introducing the new Polish simple joint stock company, there were a lot of arguments raised. The first problem was with minimum share. In Polish law, until quite recently, you had to have a significant amount of capital to set up a company. €1, $1 was not enough. Then it was regarded as a barrier to enter the market, to set up the company. And the idea was to lower the requirement of minimal share capital in the existing LTD. But the attempt to change the law, lower this capital, failed. There were a lot of protests that it shouldn't be allowed to use the limited liability for companies with capital of €1 only. And this is why the legislator came up with a new idea. let's introduce a new model of company, a new type of company, which you can set up when you have €1. So don't change the existing law because it's too controversial. This was the trigger of this laboratory and innovation. And then the legislature decided to introduce much more innovative company law instruments. In terms of statistics, you see that now there are about more than 2,000 simple joint stock companies. It's very few comparing to limited liability companies. We have almost 500,000 of them in Poland, or other kinds of companies. So truly, the new form works with laboratory in a very limited scale. The discussion about the new form of company also resulted in producing arguments supporting or saying that this new form is particularly addressed for it's going to be a laboratory for corporate law, and it's going to be the most flexible, and it's going to allow to set up the company more according to the wishes of shareholders in the most flexible way. Therefore, there are plenty of default provisions. So the articles of association may be shaped as shareholders wish. The new form of company is regulated inside the commercial companies code, but as you see, the articles are added. This is why you have these upper numbers, because there was no room in the code for this new type at the time when the code was done. And the regulation is quite extensive. It's 134 articles about this new form of company. In our code, the general part is very limited. So as a result, a lot of rules for the new company are the same as for the old companies. There is just copy-paste technique. But also, there is a lot of new regulations. But even regarding the old rules, there is an interesting discussion in doctrine and literature if these old rules could be used, applied, interpreted in the same way, because now they are in different environments. A simple joint stock company is not unique in comparative sense. This is what I meant at the beginning, saying about innovations. There is another example which was used for Polish law, but it's different, but to some extent only similar. This is the French example. In France, they have La Société par Action Simplifiée. That is a simple joint stock company, SAS, that was introduced in 1994. And it is regulated in the French Code de Commerce. However, as you can see, there are only 20 articles. In Poland, 134. So Polish regulation is much more precise, detailed, and elaborate. In France, La Société par Action Simplifiée is a type of private company. And if there are lacuna gaps in the regulations, then you should apply the law on corporations, joint stock companies, Société Anonyme. The rules, the French rules are also very flexible, and this is what the French company and the Polish company have in. Now, when we look at the Polish and innovation of the Polish simple joint stock company, we will look first at key features of this company and then at some examples of innovation, like the concept of simple joint stock company in organization, types of contributions that are allowed, a lot of minimum share capital, different specific types of shares that we have in this company, some innovations regarding corporate governance that is optional, and some innovations in the field of liability of directors. And finally, some innovations regarding general meeting. Starting from key features of a simple joint stock company, it is a legal person. It acquires legal personality at the moment of registration. So, as a legal person, it is an autonomous subject of law. The liability of shareholders is excluded, so only the company is liable for its debts. The shares are transferable. We have delegated management, support structure, and investor ownership. So basically, we have all the five elements, features that are commonly recognized and key features for every corporation. So absolutely, this is a type of corporation. However, it may be formed for any legitimate purpose. So not only for profit. It may be set up to conduct business activity, economic activity, but not necessarily. So this is very flexible at the output. Then, when we look at the innovation, let's start with a very unique concept, totally unknown in the common law world, known in some civil law jurisdictions to some extent, the concept of company organization. When you think of setting up a company, there are always several steps to follow. One important step is when you sign the document, sign the contract of the company, the articles of association, the corporate charter, however you call it. The next important, there are several mixed steps, but the next important step is registration. And one should ask, what are the legal consequences of signing the document? Because the legal consequences of registration are clear. The company is at time of registration, it becomes a legal person. But as lawyers do know that signing contracts is always meaningful. So what is the meaning? What is the consequence of signing the contract if at this very moment the company is not born? Not born yet. And here, the concept of company organization may help. Because according to this law, at the moment of signing the document, a simple joint stock company organization is not a legal person. It acquires legal personality at the time of registration. But it is a separate legal entity, like a partnership. So it may operate, it may conclude contracts. It is in business already, so after the usual, you can start doing business activity. It is represented by directors, and before, until directors are elected, it is represented by the plenipotentiary appointed by our. Another innovation that we can find in this new Polish type of company are specific special kinds of contributions. We know that making a contribution is a key element to form a company. And generally in company law, we recognize two types of contributions, cash contributions and non-cash contributions. However, in most jurisdictions, in most cases, some non-cash contributions are not allowed. Particularly contribution in the form of performing work for the company or services to the company. This is not the case of simple joint stock company. Here, these kind of contributions are allowed. So one shareholder may contribute by providing the money, whereas other shareholder may contribute by providing his or her work or his or her service. I will get back to these kinds of contributions in the context of startups in the third part of the presentation. Another innovation that we have here is the problem of minimum share capital. As I said before, in Polish law, when you want to set up a company, you have to have a certain capital. And it was regarded as kind of a, so the new company, you can start with one Polish zloty. Because you may not be aware that in Poland we don't have euros. We have our own Polish currency. It's a Polish zloty, and one zloty is about two RMBs. So, but you need very little money to set up such a company. The amount of capital is not determined in the articles of association. So when you draft the article of association, you don't write down in the articles how much capital is in the company. What's the consequence? It's clear. It's very easy. It's very flexible to change the amount of the capital. You don't have to go through the procedure of amending the articles of association. Further consequence of lack of minimum capital is that when you have shares, have a nominal value. They don't constitute a part, they don't constitute part of share capital. So the concept of share is totally different. You have only precisely defined rights and duties connected with a share, not part of the capital. The lack of capital, another consequence of lack of share capital is that it's easy or much easier than in other companies to pay to the shareholders out of the capital of the company. Because again, you don't have to go through any procedure aimed at lowering minimum share capital because there is no minimum, there is no share capital in the article of association. The next innovation is about the different specific types of share. In this company, must have the document form. They are only elected. This is kind of a common standard these days. However, what's more unique is that shares are registered in the register of shareholders, and such a register is kept by the company. Every company must keep this register. And they use very modern technology, like blockchain database, to keep this register. Shares must be traded on a stock exchange. So it means that simple joint stock company is a type of closed corporation. So you can trade the shares only in traditional way by contract. But what's the most important and most innovative are specific types of shares that if you want, you may introduce to this company in the articles of association. There are two specific types of shares. First type is called preference shares. And you can imagine a lot of different types of preference that may be attached to the share. The most common is the preference with regard to votes. So you have the starting point, the principle, one share, one vote, but you can easily, by this preference share, change this concept. And you can change this concept in normal, because you may attach to an individual share as many votes as you like, even 1 million. There is no limit. And this is unique in the context of Polish law, because in other Polish companies, you may create preference shares. There is a cap, a finite cap regarding the number of votes that you can attach to an individual share. And what's even more innovative is another type of shares that are called founder shares. These shares, as the name says, usually may be given only to the shareholders who set up the company, so the first shareholders. However, the law is so flexible that if the shareholders decide so, they can set up founder share even later, or future coming shareholders. And the idea behind outer shares is very unique because it means that somebody who has this kind of share will always have certain percentage of vote. For example, if there is a founder, a person who has the most crucial idea behind a company, he or she may be given a founder share that would have 51% of votes. And it will give him always majority of votes. Later, when new shares are produced, for example, 1 billion of new shares, then in a traditional environment, there could be water stopping of his share. So he would lose this majority. But if he has this other share, whenever new shares are produced, automatically the number of votes attached to his or her share goes down. So always, regardless of the total number of votes of all shares, he or she will always keep this 51. So always he or she will control over the money. And it will happen automatically. He or she does not have to buy any new shares. Automatically, the number of votes his or her share will go up. A very unique concept. I will get back to this in the context of startup in the third part of the presentation as well. The next innovation regarding corporate governance is that here we have an optional model that is also very flexible. So it means that it's totally up to the shareholders to decide what kind of system of corporate governance they want to have in their company. They may go for either for a tier model, like in German law and in a Polish law in other companies. So they may have separate bodies, management board and supervisory. Or they can go for common law system, one tier system with one board of directors. They are free to choose what they like. If they go for the first model with management board and supervisory board, then management board is in charge of managing the affairs of the company and representing the company toward third parties. Members are appointed and recalled by shareholders. However, again, flexibility, it may be changed. So, for example, one shareholder may be given a personal privilege to appoint one member of the board. Keep his or her representative in the board. Or if a supervisory board is established, then supervisory board may be in charge of appointing members for the management. We also adopted say-on-pay rule. So shareholders, if they want flexibility again, may determine the maximum remuneration of the members of the board. So they keep control how much the director will earn. Supervisory board in this model must consist of minimum 3 members who are appointed and recalled by shareholders. However, again, flexibility, it may be changed. Supervisory board exercise day-to-day supervision over the activity of the company. However, it is not allowed to give binding instructions to the management board. So there is a wall between management and supervision. If shareholders go for one tier model, so board of directors, then the board of directors is in charge of managing the company, representing the company towards third parties, also exercising supervision. And directors may be appointed and recalled by shareholders, but flexibility again, it may be regulated differently. There may be, if shareholders want so, groups of directors within the board, managing director and non-managing directors. And also in this case, we have the rule saying on. There is one innovation that was not introduced, and it is kind of an open question, an open discussion. Maybe now, when we have the technology that allows us to stay in touch all the time, there is no need for meetings of because they may work permanently thanks to technology. Maybe the entire concept of meetings of boards is not necessary any longer. This was discussed but not introduced yet. Now, in the field of liability of directors, three duties of directors are detailedly regulated. Legality, so directors must act according to law, loyalty, and they now are grounded in statutory law, not only in case law. Also, business judgment rule is clearly regulated, and the law says that a director will not violate the duty of care if, remaining loyal to the company, he acts within the limits of justified economic risk. So we have clear statutory regulation of this rule. And this is also an interesting example because this was new in Polish law. It was tested in this simple joint stock company. It worked well, and then it was transplanted, and now we have the same rule with regard to other types of provisions. Finally, general meetings, interesting regulations. Resolutions of shareholders may be adopted either during the meeting or even without the meeting, outside the meeting, by remote voting. General meetings, this is not new now after the pandemic, but at some point it was new, may be held either personally or remotely. And this is interesting, and new in Polish law, general meetings may be held anywhere, not only at the place where it's the seat of the company. It may be in Shenzhen, in Hong Kong, wherever shareholders decide to have it, not only in Poland. However, if such a meeting is held outside Poland, resolutions will require drawing up by a public notary may not be adopted, but otherwise they may be held anywhere. And with regard to general meetings, there is also lack of one innovation that was discussed, and it's also a question about the need of general meetings. Maybe because of technology, now general meetings of shareholders are not necessary anymore because shareholders may take decisions on everyday basis, thanks to voting by emails or in any other way. Finally, when we look at the third part of the presentation, and when we think of this methodology of change and the innovations, we need to ask, okay, we would like to promote startups. So should we change corporate law in a way that will promote startups in a special way? To answer this question, and automatically to answer the question if the new form of company is a good answer to the needs of the startups, we should start from thinking about those features of corporate form that may be liked, loved, and required by startups. Firstly, flexibility. Startups are different, and they like to shape the corporation as they want. Then, easiness to set up a company. So, online registration, even in a form of kind of an online form that is easy to fill in. Maybe a legal model of articles of association. Then you have the online fill the form and voila, you have a corporation. Lack of minimum share capital. Startup is about idea, not about the money, at least at the beginning. So at the beginning, you may have a garage shop, not money. So then you need to be able to set up a company without money at the outset. And you don't have the money to pay the lawyers and others to pay any cost connected with incorporation. They will be off. Also, when you are the genius, you have an idea and you would like to use this idea and your contribution. So you need a type of contributions. You say, okay, I'm establishing this corporation. So my idea, my service to the company is my contribution that is worth 60% of both. You should be able to contribute this. And when you have this idea, you are always afraid that it may be stolen at some point. Your startup may be stolen by others. Your stock may be water stock. There may be share dilution. So you need to kind of protect founders against. And now we know that, for example, the instrument of this founder share is designed to protect against this risk. The question is, to meet all these requirements, we need to create a new corporate form, or maybe it's better to change the already existing type of company that we have. So we are back at the first part of the lecture. What to do to meet the needs of startups, to amend the existing law, or to introduce a new corporate form for startups. And we could say that now, the first part, we know that potentially both approaches are possible, and there are risks connected with both approaches. So the question amendments or reform may be theoretical, as I tried to put it at the beginning. As you see, it's also very, very practical when you see the same question in the context of. Thank you very much for your attention, and I'm very happy to take any questions or comments if you have. Thank you.